Please, Your Lordship. Your Lordship, I'm making a mention, which is unlisted matter, my Lord. I'm praying that the matter will be listed tomorrow.
What's the urgency?
My Lord, here, if Your Lordship recall, there's an appeal before a division bench, an arbitration appeal, my Lord, wherein the division bench dismissed this said appeal. Now, subsequently, my Lord, they have filed an application before execution court under 151 CPC, wherein, despite strong objection, my Lord, the execution court allowed the application, staying the execution proceedings. So, the grievances is only pertaining to that, my Lordship.
Oh, that is contrary to the judgment of the division bench.
Not exactly, my Lord. My Lord, the execution proceeding was pending since the year 2018. Now, subsequently, they have filed an application under 151 CPC. And despite our strong objection, my Lord, the commercial court allowed the application filed by the NIPCO and the execution proceeding was stayed.
Okay.
Tomorrow, tomorrow.
Yes, Lordship, I beg to mention number 15. To let this matter after 2 weeks. To let this matter after 2 weeks. Item number 15. 1-5.
Who's for the respondent?
Yes, 1-5.
On pre-made by the petitioner. This is matter of the 2 weeks.
Highly.
Item number 17, my Lord.
Yes.
Taken after some time, after 2 weeks.
Let it come after 3 weeks, Your Lordship. And in the meantime, if Your Lordship may kindly call the entire records of the court-martial proceedings, Your Honor. So, because we shall be relying on some of the documents which are there in the court-martial proceedings.
Are you privy to this record?
Yes, Your Lordship.
He is entitled to them.
Well, in fact, in earlier matters, they have to apply for that matter. They have to write an appeal. As per the rules, they have to apply for it.
Have you applied?
Yes.
So it must have supplied to you then.
Okay, we'll give it 3 weeks time and we'll see how it goes.
My Lord.
Oblige, Your Lordship.
On pre-made by the parties. This is matter of the 3 weeks.
My Lord, 11, 12 and 13, this is CBI matters, my Lord. Mr. Gautam is in the other side.
No objection.
Up to 2 or 3 weeks.
On pre-made by the respondent, not objected to by petitioner. This is matter of the 2 weeks.
Much better.
Please, Your Lordship. Lordship, I beg to make a mention in item number 7, Your Lordship.
(2014) matter.
Lordship, due to some personal difficulty, Your Lordship, Mr. Paul Kundan.
You are for?
Petitioner, Your Lordship.
Petitioner. What is this matter about?
But this is the subsidy matter, Lordship, we heard in the department.
On pre-made by the petitioner seeking further accommodation on ground of the Unit Senior Counsel who is conducting the matter not being available today. The same is allowed. This is matter to 1 week.
Similar prayer for item 14, Your Lordship.
You are for? Petitioner. Does it send you here?
Of the respondent, state.
What's this matter about?
No, this was a proceeding under the Drugs and Cosmetics Act, and the court had sought to alter certain charges. So they're against, they're before this court challenging that order.
Where is the scope? Fine. On premier by the petitioner, this is matter to 2 weeks.
Obliged.
Lordship, on item 16, Lordship will go for a joint prayer, Lordship.
Lordship.
On premier by the parties, this is matter to 3 weeks.
Obliged.
My lord, I beg to mention item number 9. Item number 9, my lord. My lord, in this matter, I have been informed that the matter has been heard already. We are at the stage of filing of a written submission. My friend who is appearing for the petition, they have already filed. State has not filed yet. My lord, the counsel, my colleagues who are appearing in this matter, they are all sick, my lord, and unwell. So, my lord, due to that, I'm praying for some more time. Your lordship can give
Have
me
you filed
2 weeks
yours?
time.
Yes, Your Lordship.
Excuse me. On premier by the respondent, seeking more time to file the written argument, the same is allowed. This is matter to 2 weeks.
Highly obliged, lordship.
Yeah, please, Your Lordship. I'd like to mention item number 10, Lordship.
Number?
Item number 10. The Learned Counsel for the petitioner, Mr. A. Barwa, is currently available due to personal difficulties,
My
Lordship.
lord, Mr. Barua has actually called me also. He was taking care of his mother all this while and who has been declared to have cancer yesterday. So you have to rush to some other hospital, my lord, to the bigger city. So my lord can give a longer date because we do not know how long will it take for the treatment.
Prayer has been made on behalf of the Learned Counsel for the petitioner, who is said to be indisposed on grounds of personal difficulty. On the prayer not being objected, same is allowed. As prayed for, this is matter after 3 weeks.
My lord, I appear for the corporation. My senior appears for the state here.
Yeah, please, Your Lordship. Lordship, I beg to mention item number 18.
Yes.
Item number 18 for 2 weeks, Your Lordship.
Contempt. It's a contempt matter.
Contempt petition.
Negligence.
On prayed by the petitioner, this is matter after 3 weeks.
May I please, Your Lordship, I beg to mention item number 8. Since the senior counsel is indisposed, Your Lordship, for today, so I pray for 2 more weeks.
This matter was heard.
A part of it, Your Lordship.
It was heard last year, my lords. I had pointed out there was a defect with the prayer,
Okay, over that.
following which they filed an application for amendment of the writ petition. So it's to be heard on that amendment application.
So we are yet to go into the root of the yes, amendment of the prayer, isn't it?
Lordship. Amendment.
On prayer made by the petitioner, this is matter to 2 weeks.
Highly obliged.
Much obliged, Your Lordship.
May I please, Your Lordship? My Lord, I would like to mention item number 20. My Lord, I humble pray for 1 week time since the conducting counsel for the petitioner could not be present today before this honorable court, Your Lordship, due to some personal difficulties.
You are in this case?
And for respondent number 5.
On prayer made by the petitioner, this is matter after 3 weeks.
Highly obliged.
On supplementary cause list, item number 1.
May it please your lordship, this is an application under 482 Malat, seeking quashing of the proceeding before the Learned Court of GMFC Jawai Malat. It emanates from GR case number 197 of 2018. Now, lordship, in this case, what had happened is there was a dispute at the Nartyang Durga temple, my lord, with regard to the priest who would be entitled to perform the pujas there. And there was some dispute that arose between two rival groups who claimed that the priest from their group should perform the puja, my lord. And to that effect, my lord, there was a proceeding which was initiated before this honorable court on the earlier round of litigation, and there were some orders passed, my lord. Your lordship will find that order at page 13, annexure 1.
Yes.
I'll just, my lord, paragraph 1 is not so relevant, so I'll read from paragraph 2. Now, it has been claimed that there was no resolution in the public meeting held on so-and-so to decide the next priest, as the respondents had been repeatedly creating a situation of turmoil in the Nartyang village as they could not choose a priest of their choice. Paragraph 3, Lord, learned counsel for the parties agreed that during the pendency of the writ petition, the dispute has been amicably settled between the parties, and Shri so-and-so, whose family has been performing the ritual as priest for 26 generations, has been allowed to continue as a priest of Nartyang Durga temple. It was thus prayed that in view of the above, the writ petition has been rendered infructuous and may be disposed as such, ordered accordingly. Now, your lordship, apparently at that point of time, the parties had settled the matter. Now, your lordship, after this order was passed, my lord, again some skirmish happened in the same area, my lord. And as such, the police officer concerned, my lord, they filed an FIR. My lord, filed an FIR against the people involved. Of course, it was stated, my lord, the entire locality was involved in the skirmish. Now, your lordship, on the basis of that FIR, my lord, a charge sheet was filed, and it was filed under section 188 and 109. Now, my lord, after the charge sheet was filed, during the stage of consideration of charge, my lord, the petitioner herein, of course, the charge sheet was, even though, my lord, the allegation was against the entire locality. Interestingly and very surprisingly, my lord, the charge sheet was filed only against one accused person, even though it was alleged the entire locality was involved. I do not know the logic behind it, my lord, but still the charge sheet was filed only against the petitioner herein. Now, your lordship,
perhaps he is the only one who has been identified.
My lord, maybe, my lord, but then it is something which is highly improbable, my lord. The entire locality was involved. Only to single out one person and file a charge sheet against it is quite, my lord, baffling. My lord, thereafter, my lord, at the stage of CC, my lord, we brought this to the Honorable Learned Court below's notice, my lord, that the parties have settled the matter. And since the parties have settled the matter, my lord, it may be compounded. The Learned Trial Court, my lord, expresses an inability to compound the matter because section 188 is non-compoundable.
You say party have settled the matter in what sense?
Parties have settled, my lord, it is recorded in 180, the High Court's order, my lord.
Yes, but then you said that...
Now, that is why, my lord.
You see, that episode being over.
Yes.
Fresh episode has occurred, out of which
the entire issue was with regard to who will perform the puja.
Yes, that is true.
That issue has been settled already. So in that sense, my lord, I'm saying we said before we brought it. I mean, we put forward before the Honorable Court that the parties have settled the issue because the entire issue was with regard to the priest who would be entitled to perform puja.
You have to prove the factum of settlement.
My lord, that is what, my lord, here, my lord, the fact that the puja is happening in normalcy and the priest who was originally chosen has been performing and there is no untoward incident till date would suggest, my lord, the parties have settled the issue. And, my lord, your lordship, I'll take your lordship to the Learned Trials Court order dated 5/1/2023. I'll just read the operative portion. Your lordship will find that at page 47.
Yes.
If I may read, your lordship. On hearing both learned counsel, Paris record and found that the section alleged against the accused person who is so-and-so is under section 109, 188, and on perusal of the said section found that the same are non-compoundable. Hence, this court is of the view that the fact that the matter has been settled and resolved by the parties is not maintainable. Furthermore, on perusal of the statement of so-and-so, 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 there is a prima facie case against accused so-and-so for offence under section 109 IPC. My lord, even though, my lord, the matters have now been settled already, that is one limb of argument. The other aspect, my lord, is section 188, my lord, could not even have been invoked in the manner in which it was filed in, invoked in this case. Because your lordship is aware, section 188, my lord, there's a bar under 195. If you are, yes, there's a bar under 195 of CRPC, your lordship. It cannot be by way of an FIR.
Let us see. Look at 188 first. What does it say?
195, my lord.
No, 188 first. What does it say? That's IPC.
IPC 188, my lord. If your lordship has got it,
Yes.
May I read, my lord? 188, disobedience to orders duly promulgated by public servant. Whoever, knowing that by an order promulgated by a public servant lawfully empowered to promulgate such order, is directed to abstain from a certain act or to take certain orders with certain property in his possession or under his management, disobey such direction, shall, if such disobedience cause or tends to cause obstruction, annoyance or injury or risk of obstruction, annoyance or injury to any person lawfully employed, be punished with simple imprisonment for a term which may extend to 1 month, or with fine which may extend to 200, or with both. I'll continue, your lordship. And if such obedience cause or tends to cause danger to human life, health or safety, or cause or tend to cause a riot or affray, shall be punished with imprisonment of either description for a term which may extend to 6 months, or with fine which may extend to 1,000 rupees, or with both. Now, your lordship, this has to be read in the context of section 195 of CRPC, your lordship.
What does 195 says?
There's a bar under section 195 to proceed under section 188 by way of an FIR. There has to be a complaint in terms of section 195. Prosecution for contempt of lawful authority of public servant, for offences against public justice, and for offence relating to document given in evidence. No court shall take cognizance of any offence punishable under section 172 to 188, both inclusive of the IPC, my lord. It has to be read, my lord. I'll skip the other portion, my lord. I'll just take your lordship to the proviso, except on a complaint in writing of that court, or by such officer of the court as that court may authorize in writing in this behalf, or of some other court to which that court is subordinate. Apparently, in this particular case, my lord, there was no complaint whatsoever. In my humble and respectful submission, my lord, the proceeding could not have been even initiated on the basis of FIR.
An FIR is a complaint?
It's not a complaint, my lord. I'll take your lordship to the definition of a complaint.
Yes, of course. It is an information, no?
It is an information, my lord. Complaint is, by complaint, they mean, my lord, the complaint under section 200.
200.
Not an FIR. And my lord, in my humble and respectful, there's no, my lord, no useful purpose would be served even if this proceeding is kept alive, because the parties have already amicably settled the matter. They are happily performing pujas without any incident or any issues of any kind.
Yes, who's appearing?
That informant was as a party, private. I am for the state lordship, private respondent, my lord.
You're for private respondent?
No, I am for the state lordship. So there is one private respondent. The informant was made as a party, my lord. Let notice be issued to the.
Who is the private respondent here?
My lord, private respondent is respondent number 3.
The officer in charge of Natyang police station has filed the FIR, lordship. Now my friend is talking about that.
But he's an official.
That's an officer. Settlement. That he was talking about the matter has been settled with the private party, not because the case has been filed by the officer in charge of police station. Now, whatever matter has been settled with two rival groups, not with the persons who are the victim and who lost the FIR lordship. Now that so far as the settlement of the matter is concerned, is not connected, is not will not any will not help this case lordship. Here, because the settlement was done between two rival parties, not with the police officer lordship. Here, lot of police officers, while implementing the court order lordship, they were assaulted by the mob led by the petitioner lordship. That is why his name has been charge sheeted lordship. That is at page lordship 26 lordship. And it is a case of under section 109 and 188 lordship. This is the authority part of the charge sheet lordship. During the course of investigation, from the statement of the victim and the witnesses were recorded under section 161 of CRPC, it is found that the name of accused Sri so-and-so had instigated and averted the group of villagers so as to cause law and order problem in the Durga Mandir, Nartiang, and obstructed the police personnel on duty despite the order of the Honorable High Court, that is so-and-so. Under the above circumstances, a prima facie case of so-and-so is found well established against the arrested accused person so-and-so.
So you're not accepting notice on behalf of the respondent 3?
No, lordship. This is because by name he has issued notice, lordship. So, and moreover, there are lots of victim, lordship. So
There may be a number of victims. That is beside the point. That would only matter as far as investigation is concerned.
They should have added as a party also, because since
how can they be added as parties?
Because the FIR was not from the victim, or the so-called victim.
FIR is from somebody else. So I was taking cognizance of the contents of the FIR.
Even if I abandon that argument of settlement, this proceeding would not sustain in view of the bar under section 195, my lord.
That will be looked at.
Let it to take step, lordship, the private respondent.
So you will accept notice on behalf of 1 and 2?
1 and 2.
Heard Mr. Estapa, learned counsel for the petitioner. Mr. Sheikh, you are the GA now?
GA.
So S.A. Sheikh, learned GA, has accepted notice
1 and 2.
On behalf of the respondent 1 and 2. The petitioner is directed to take steps for issue of notice upon the respondent 3. CM returnable within 2 weeks.
May I pray for the LC records be called, my lord? It might be necessary for the purposes of...
That will be after effecting the notice, lordship.
Yes.
Otherwise it would amount to staying the suit, lordship. Staying the proceeding, lordship.
Excuse me.
Deeply obliged.
Item number 2.
May I please, Your Lordship? Lordship, this is for motion. I had mentioned it a couple of days ago, my lord. If I may briefly take Your Lordship to what has happened, my lord. The petitioner, my lord, is the employer of the school known as St. John's School, Whitehall. This school, my lord, has been in existence since the 90s and has imparted education to the students of Shillong specifically without any blemish, my lord. Now, what has happened, my lord, is that this school is under the ambit of the EPF Act, my lord, Employees Provident Fund Act. So they have to make the necessary contributions as per the Act. Now, on an earlier round of litigation, my lord, an impugned order for damages were issued. That was for the period of lordship. That was for the period of 1996 to 1999. After the hearing of both the sides, my lord, the writ petition was allowed, and that impugned notice was set aside, and the petitioner school was directed and allowed to pay 25% of the damages. That is as per the amendment, my lord. Then thereafter, my lord, they have been paying on regular basis
and there is no dispute about that. Lordship, directly in 2023, which is the Lordship may come to page 35. Page 35 of my writ, my lord, is annexure 2.
Yes.
35 is only the cover letter, my lord. The order starts from the next page at page 36, Lordship. If I may just read, Lordship, this is dated 14th of February 2023. From 1999 till now, there is nothing, my lord. This is the only thing that has come. Order of the Regional Providence so-and-so under Section 7Q of the Act in respect of MS St. John's School, Whitehall, Dum Dum, Shillong, having PF code number so-and-so, my lord. Whereas the school to which EPF and MP Act 1952 applies were required to pay Provident Fund contribution under Section 6, EPF contribution under Section 6A, Insurance Fund contribution under 6C, administrative charges under Para 38 of the scheme of 1952 and Para 8 of the EDLI scheme 1976. And whereas the employer in relation to the said establishment failed to pay within the prescribed time limit as required by law for the period of, Lordship, kindly take note, February 1992 to April 2008. On one hand, my lord, after a round of litigation, this period of 1996 to 1999 was already settled. Till 2023, nothing has been issued to me. On February 2023, they issue a notice under 7Q, my lord, saying that I have failed payments from February 1992 till April 2008. From April 2008 till 2023, nothing, my lord. And how they have arrived to the 1992 also is, my lord, without any basis. Thereafter, my lord, proceedings. Whereas summon was issued to the employer, so such and such, he was afforded. So the second paragraph, my lord, and whereas an order under Section 7Q of the Act has been issued after affording opportunity to the establishment levying damages for the delayed payments of contribution and administrative charges for the period of February 1992 to April 2008, totaling to 4,63,871. It is ordered that the establishment is liable to pay the following amount under Section 7Q of the Act on account of belated remittances and of contributions and administrative charges for the same period, as per account-wise schedule indicated below. Lordship will have the table in the next page, my lord.
Yes.
Here, my lord, the table in the next page interestingly says that the total amount is roughly about 1,28,000. Whereas Lordship has just seen on the previous page, they are saying that the amount is somewhere around 4.6 lakhs. So this has been given, my lord, that I further order that the amount shall be paid by the aforesaid employer into the respective EPF accounts maintained in the SBI within 7 days, failing which action under Section 8 will be taken to recover the amount, my lord.
Yes.
Lordship, there is no seal and date, but I am not on that. Lordship will kindly come to the next page, my lord, page 38, which is again an order of the same date, my lord. 14-2. The order is on the subsequent page, my lord, at page 39. This is the cover letter, my lord. Page 39, my lord. Again is an order on the 14th February 2023. The heading, my lord, order of the RPF Commissioner under Section 14B. So the earlier order was under 7Q, Lordship.
Okay.
This order is under 14B, passed on the same date. Here, my lord, Lordship will see in bold in the second paragraph, the same period has been reflected. 02/1992.
You see order under 14?
14B.
14B.
That
What
is
is
right in
14B?
the heading, my lord. 14B.
What does 14B say?
14B is in connection with recovery of damages, my lord.
And 7Q?
7Q is for default.
Default. Or to recover damages.
So So we are not on. So this order at page 39, my lord, passed under 14B.
So see, 14B is a is a consequence of 7Q.
Yes, they have to be put together. So the order at page 39, my lord.
Yes.
I am reading the second paragraph. And whereas the employer in relation to the said establishment failed to pay within the prescribed time limit as required by the law for the period, again my lord, February to 1992 to April 2008. So this is the same period which they are also alleging under 7Q, lordship. Lordship, thereafter kindly see the proceeding, my lord, in the same order itself. If I may read, my lord. And whereas summons was issued to the employer by this office, letter dated such and such, along with the statement of payment for levy of damages under section 14B of the Act, which the establishments also afforded the opportunity for personal hearing and proceedings thereof were fixed on 29/12/2021. And whereas due to the leave of the assigned officer, hearing could not be conducted on 29/12/2021, the next date of hearing was fixed on 11/1/2022. Mr. Such and such, authorized signatory of the establishment, and Miss So-and-so, principal of the school, attended the proceeding. They submitted that the Honorable High Court order wherein damages and interest under section 14B and 7Q for the period March 1996 to February 1999 was ascertained and payment was accordingly made. In regards to the rest of the damage period, they requested for some more time to bring in the requisite supporting documents. Their request was granted and the next date of hearing was fixed on 24 January 2022. Received a letter from the establishment requesting for some more time. Request was accepted and the case was adjourned to 28th February. Mr. So-and-so attended the hearing on 1st March 2022. He submitted a letter of correspondence with the bank wherein they placed a request for the account statement. He requested for some more time as the bank is yet to give the requisite documents. Request was accepted and case was adjourned to 11th March. She so-and-so attended the hearing on 11th March. Again he requested for some more time as the bank is yet to give the requisite documents. Request was granted, case was adjourned to 21st of March. Then again Mr. So-and-so and Miss So-and-so, authorized signatory, attended the proceeding. They submitted a letter from the bank stating that it may take some more time for the bank to retrieve the detailed bank statement. However, they submitted the transaction statement from the bank passbook along with the challan copy of the contested period for cross-verification by the EPF office. Case was adjourned to such and such date, lordship. On scrutiny of the documents submitted by the establishment, it is seen that payment under section 7Q for the period March 1996 to February 1992, as calculated in earlier assessment, was paid by the establishment. 14B at the rate 25% of the assessed amount of rupees so-and-so was paid by the establishment for the period March 1996 to February 1999 as per the court order, and due amount of such and such rupees was also paid by the establishment. Establishment contention for the wages month April 2008 has been taken into account. On scrutiny of challan and bank statement, it is seen that contribution mentioned against April 2008 actually pertains to April 2010 and the payment was paid within time. Hence, damage and interest has been struck off. Establishment contention for wages month April 2006 has been rejected. On scrutiny of challan and bank statement, it is seen that there is actual delay in payment and hence 14B and 7Q amount is required to be paid. Revised calculation sheet was prepared and such and such. So what has happened, my lord, is that the period from 1993 to 1995 has been paid as per the direction of this honorable court. There is no due for that. The period of April 2008 was actually the period of April 2010 and that has also been paid, and it is a finding in this during this proceeding, my lord, that those periods or the dues had already been paid, which goes to show, my lord, that the order or the amount that they are now which are levying against us was probably incorrect, my lord. Thereafter, Lordship, kindly have the next page, my lord, page 40. 40, I'm reading the first line, my lord. Considering that, so earlier already they have said that certain thing has already been paid. Considering that on the basis of the challan submitted by the establishment itself shows that there was a delay, actual delay in payment for the period of February 1993 to March 1995 and from March 1999 to April 2006, and as adequate opportunities have been given, the case was concluded and closed. Now therefore I so and so, in exercise of the powers conferred on me under section 14B of the Act and on application of mine to the facts and circumstances of the case and on perusal of the relevant records, consider it fit for a case of levy of damages. I'll just skip some parts, my lord. The period again is in bold, my lord. Again, February 1992 to April 2008, totaling to 4,63,871 to be recovered from my school, my lord. Lordship will kindly appreciate that on one hand, my lord, they are saying that a certain period has already been paid in persons to this honorable court's direction. Thereafter, they are also saying that a certain period which was levied transpired to be from a different period, and that was also paid within time. Whereas, again, in the conclusion, my lord, the commissioner comes to say, he mentions the same amount of 4,68,000 without any adjustment, if anything, and the same period of from February 1992 to April 2008. Thereafter, my lord, at page 41,
yes,
page 41, my lord, upon receipt of these two orders, this is written by the authorized secretary of the school, my lord, to the respondent. She simply asked, my lord, with reference to your letter number such and such, dated so and so, please provide us a detailed calculation of damages with periods so that we can verify our records accordingly. Because apparently, my lord, there was some miscalculation. So, my lord, this letter, there was no reply forthcoming. Thereafter, my lord, at page 42, we have, my lord, through the council, a legal notice was sent to the respondents. This legal notice, my lord, kindly have page 43 onwards. Page 43, my lord. Point number 3. This will give the clear picture, my lord, that the school was brought within the purview of the Act in the year 2000, but with effect from 1982. However, the said school only had 20 employees from 1996, and therefore the said school of my client was liable to deposit the EPF dues only with effect from 1996. Thereafter, my client accordingly paid all dues as directed. That, however, the interest and penal damages with effect from February 96 to March 1999 for the alleged delay in depositing the dues was levied on the school, and eventually the matter was before the Common High Court, Shillong Bench, and the Honorable Court, by judgment dated 27th of January 2012, passed in so and so, was pleased to allow the school to pay 25% for the period of March 1996 to February 1999 in accordance with so and so clause, and that the installments already paid be adjusted against the balance payable in terms of the said order. Accordingly, my client paid the amount as per the direction of the Honorable Court, and the same was acknowledged by your good office. That, however, the said backlog of arrears, if any, from 92 to 2008 could not be paid at once, and as such my client had made payments in installments with effect from 2002. So this was the background, my lord. Thereafter, the narration of the two impugned orders are narrated, my lord. And then at point 9, lordship, at page 44. So this is the entire crux, my lord, that the allegation is that the payments are delayed from February 1992 to April 2008, whereas some of that has already been settled in terms of this Honorable Court's order. Some of them have already been paid and acknowledged, and they're even in the proceedings leading to the impugned order, I have shown to your lordship that there were some miscalculations which have been corrected. But the final amount which they are, my lord, claiming against me and the period against that amount has never been, my lord, clarified. So, lordship, this legal notice was sent in the form of a request, my lord. At page 45, lordship will kindly see that what exactly was asked. I am therefore instructed by my client to request of you, which I hereby do, to provide a detailed calculation of the damages and interest with the specific period thereon, so as to enable my client to verify the same from the office records and address the same accordingly, and further, not to proceed with the recovery of any amount from my client in pursuance to the said order. So, my lord, it was never the case that we don't want to pay or anything like that. We only asked for a clarification because apparently there was some mistake in calculation, either from our part or their part. So we asked for a clarification and we requested them to not go ahead with the recovery. My lord, the said legal notice was received and a reply came, which lordship will find at page 46, lordship.
Yes.
So the reply, my lord, was not very much on my request, but simply they told me that there is a
provision for appeal.
So, and thereafter, my lord, at page 48.
Yes.
Page 48, my lord, is the certificate. This is the final, my lord, consequence of all the impugned orders. This is the certificate under section 8, which is given to the recovery officer by the authorized officer, my lord. This certificate is dated of 17th of May, my lord. This is to certify that the sum of 4,63,871. So the amount still remains the same, my lord, which is due from so and so is to be recovered, my lord. At the bottom of the said order, lordship, kindly see annexure A.
Yes.
They have given some sort of table, my lord. Details of dues for period of 01-2012. So again the period has changed. Now it is from 1st of January 2012 to June 2021. And they have somehow found the same amount, my lord. 4,63,871, which is the same amount which they claimed was the damage under 7Q for the period 1992 till 2008. Now that period has changed to 2012 to 21 and the amount is still the same. And they have gone ahead with the recovery. Now, my lord, as a consequence to that certificate, I have made a categorical statement, lordship, in my petition that the bank account of the school, my lord, has been frozen. Kindly have page 22, my lord, of my petition. Page 22 at paragraph 16, lordship.
Yes.
The petitioner begs to state that the petitioner's school is having its bank account at SBI Rinja branch bearing account number so and so. However, since the past few weeks, the petitioner is unable to make any transaction from the said account. Upon inquiring, the bank officials have informed the petitioner the said bank account has been frozen, seized in pursuance to the above mentioned impugned orders passed by the respondents, and as such, no transactions can be made from the said account. It is to reiterate that without providing the detailed clarification / calculation as sought for by the petitioner in bona fide interest, so as to clear out the dues, if any, the impugned action of the respondent to proceed with the recovery of the said amount and freeze the bank account of the school is highly arbitrary, unreasonable, and unconstitutional. And further, the same has put the petitioner in severe stress, turmoil, agony, both mentally and financially, as well as hampering the management and welfare of the said school. So therefore, my lord, I humbly submit before your lordships today that, my lord, that it was never the intention of the petitioning school to evade any contributions, if there were any contributions to be paid by them. Apparently, my lord, there are 3 orders passed, one under 7Q, one under 14B, and one under section 8. And all these orders, my lord, talk about different periods. They talk about different calculations. I have also taken your lordship to the position that a certain period between 93 to 96 was already paid in terms of the directions of this honorable court, and that was acknowledged. Now, my lord, to finally issue the recovery certificate, as a result of which my bank account has in essence been frozen, my lord, is wholly unreasonable, because like I stated, my lord, that if there is any due, we have only asked for a clarification. So to say, my lord, this is the month, this is the amount.
No, but what about the reference to the appellate provision?
No, appeal provision, my lord, because appeal provision would be on merit, if I may humbly submit. We are not on merit, my lord. I have never said that I don't want to pay the due, or this due is not, I am not liable to pay the due. I am only on a very limited prayer, my lord, that I had asked, you had issued the order to me. From the order itself, it is apparent that there may have been some calculation mistakes, my lord. I asked you for a clarification. There was no reply. Then I sent a legal notice, not saying that you do it, not in the nature of any demand, but in the nature of a request that there appears to be some mistake in the calculation. So let us verify it, and in the meanwhile, you kindly don't proceed with the recovery. They have not done it, my lord. Of course, even I know there is a provision of appeal, my lord. They don't have to give it to me by legal notice. But the fact is that we are on the ground of equity and natural justice, my lord. That we had only asked for a clarification in bona fide interest. They could have very well given the clarification, and if there were any dues, by now we would have probably paid it also. But that has not been done. On the other hand, without any clarification, with the apparent miscalculation still on the face of it, my lord, they have issued the recovery certificate, and as a result of the recovery certificate, the entire bank account of the school has been, my lord, affected, and the entire school has been affected.
Yes.
Lordship, now let me take you to the order, Lordship, page number 39. They are asking us that we have not provided them, Lordship. The last portion of the order, I won't go through the entire order because my learned fellow has already placed the order. Last around 1, 2, 3, 4, 5, around 6 lines, last side.
Yes.
On scrutiny of challan, Lordship, are you on the line? On scrutiny of the challan.
Yes.
On scrutiny of the challan and bank statement, it was seen that there is actual delay in payment, and hence 14B and 7Q amount is required to be paid. Lordship, here now they have already made a delay in payment. 14B is power to recover damages, and 7Q is delay in payment. So they have on records they have made a delay in payment. And revised calculation sheet was prepared and sent to the establishment on 16/1/2023, Lordship. Lordship, revised calculation sheet was prepared and was sent to them, which is not on record, Lordship. Which is not on record. They have we have already provided them the revised calculation sheets. They are coming up with the allegation that we have not given them anything. We have given them, Lordship. And also, Lordship, in my reply, in my okay, let me finish up this one.
You said you have given the
revised calculation sheet.
Where is that?
They have not placed on record, Lordship. This is I have not filed my affidavit.
You have it with you.
Yes, I have with me. I have with me, but now though it's only the soft copy, I have not taken. Okay. We have with me. It was dated 16/01/2023. Lordship, when I have already provided, we have already provided them the revised calculation sheet. Now how can they come with the allegation that we have not provided anything? Revised calculation sheet contains entire, means like suppose all from the details. All the details from month, suppose March to 1992. So from 1 to 15 is their time. So when they have paid, everything, all the details contains, but they have not enclosed here. So they have come here with not even with a clean hand, Lordship. They have not given the means revised calculation sheet. If they are so alleging, they should have come with clean hand. They should have given the revised calculation sheet. That yes, in the revised calculation sheet also we have not given them, provided what they need. Now, thereafter, was prepared and sent to the establishment with the direction to attend the hearing, which was fixed on 20/01/23. Mr. So-and-so attended the proceedings. He was apprised the basis on which the revised calculation sheet was made. He was already apprised. We have cooperated with them. We have already apprised them that revised calculation sheet was made, and their contention, aside from the damage period, to 1993 to 3 1995, and from 3 1999 to 4 2006 was taken into account. And in the revised calculation sheets, we have taken into account what are the months they have paid on time. Detailed reason in the revised calculation sheet given. So now, if we have given them entire thing, they have not placed it before records, then it is not with me, because I am now just I have not filed my affidavit till now. Even in my annexure 6, in my reply, Lordship, if your Lordship, I can draw your attention in my reply.
Yes.
In my reply, I have already stated in the last paragraph, Lordship, page number 47.
Yes.
Revised calculation sheet of damage due is provided to your client along with the daily order sheet.
Mr.
Lordship, if I may again take your Lordship to page 40, my Lord.
Yes.
What was the position, my Lord, is that a certain a demand of 4,63,871 was initially made for a period of February 1992 till April 2008. We said, my Lord, that this appears to be mistaken, because already for certain period within that damage period, alleged, has already been paid.
But considering, I think that aspect has been considered in as much as they have filed they have given you the revised calculation.
Yes, kindly see, my Lord, what has happened. The conclusion, page 40, my Lord.
Yes.
Considering that on the basis of the challans, so this is after the revised calculation sheet was given, admittedly, my Lord, there was an actual delay in payment for the period February 1993 to March 1995, and from March 1999 to April 2006. So after the revised calculation sheet, from February 92, it has come to March 1999, to February 1993, and again certain period has been left out, certain period has again been brought in, my Lord. But
so if there's any discrepancy as far as the period is concerned, I believe that would have been explained in the revised calculation sheet given to you.
That revised calculation sheet, my Lord, gave a certain calculation. But my case here is that the impugned order which has been passed does not take into consideration the revised calculation sheet. Kindly see, my Lord, the impugned order at page 48, which is the culmination of the entire proceeding.
Yes.
Lordship, if as per the revised calculation sheet, there was a delay in 1993 to 1995 and again from 1999 to 2006, then, my Lord, there was no question of the delay of due for period beginning from 1st February 2012 to 6th to June 2021, and the amount still remains to be the same.
Yes, what is this?
Lordship, I have to clarify in this.
Which is exactly my point.
But Lordship, the thing is that, Lordship, I'll just clarify on this. And but the Lordship, moreover, Lordship, I have already stressed on appeal, Lordship. Now the thing is that if they are aggrieved by the order passed by the commissioner, they have a provision to go to appeal. Now, Lordship, the practical proposition why they have not gone for appeal is that they have to deposit some amount before the appellate authority. And the appellate authority is in Guwahati.
25% you mean?
25%. So 25% they have to deposit. To avoid that 25%, Lordship, they have come before this Honorable Court.
But you see, submission has been made at the bar. It is not a question of trying to avoid what is due. It is just a question of knowing what is the exact amount and for what period.
Because apparently,
but now apparently there's a, you see, I think there's a confusion in the exact period. Even in your
in their orders itself.
In your order, you have, I don't know, whether it's inadvertence or perhaps it's correct reflection of your records.
No, we are not ascribing any blame. I am only asking that, see, there appears to be some discrepancies. Maybe because of clerical error or whatever, let you give us a final calculation, we will match it, pay it.
In the final analysis, what would appear is this, that there are dues to be paid by the petitioner, for which the petitioner is willing.
Yes.
The only things now is for you to sit and discuss and work out the exact amount and for the exact period.
Absolutely.
And then I think that matter would done there.
Absolutely, Lordship.
Lordship, let
but
them
in the
come.
meantime, you have proceeded further by issuing this recovery letter.
That is why
that in effect has affected their functioning also.
Lordship, we have acted within our power only, Lordship, and we after passing the order, Lordship, the order was on 14/2/2023. Thereafter, Lordship, only in May 2023, 17 May 2023, we have passed order under Section 8. Recover. This is under recovery officer. The first this order is 1402. Our revised calculation sheet is 1601. After 1 month, 1402, we have passed this order. And after a lapse of 2 months, February, March, April, May. After a lapse of 3 months, 1705, we have passed.
What happened is, in the meantime, if you look at the records, that communication is there in March.
Yes.
Against your letter, of February. Lordship. Then you have replied in April.
Lordship.
Thereafter, the May notification has come.
Initially, they did not reply until the time we sent the legal notice.
What you can do, this court can suggest one thing, is for the parties to sit and discuss and work out.
Absolutely.
I don't think it is not a question of, rather, as has been understood, it is not that the petitioner is not willing to comply with whatever is due.
Absolutely, my lord.
Perhaps there may have been some misunderstanding here and there.
Since Lordship, kindly see the period also, if at all.
Yes, that has to be sorted out.
It has to be, my lord,
now you yourself cannot explain that 21. Yeah.
And how the amount still remains the same. So my prayer, my lord, today would be, if they can only give us a detailed calculation.
You can do a thing, like I said, you sit together.
Absolutely, Lordship.
And then work it out. Work it out.
Very well, my lord. My only prayer would be that in the meantime, my lord, this proceeding has to be stayed, Lordship.
Within 1 week, I think you can sort out the matter.
Lordship. Lordship, I'll be on leave from 13 to, because my Lordship is aware, last year my father expired. So this in the month of June, by
you suggested
after 20th June, Lordship.
20th.
Yes.
Heard. Then the counsel petitioner, the respondent has been is represented by Ms. P. Chatterjee, Learned Counsel for the Learned Counsel. You are standing counsel or
standing counsel?
Standing counsel.
Have to take steps on respondent 4.
Oh.
The bank.
Petitioner has submitted that he may be allowed to take steps for issue of notice upon the respondent number 4. Bank. Without going to the merits of the submission made at this juncture, suffice it to say that the parties have agreed to sit down and discuss the matter pertaining to the issue of dispute and to sort out any differences, if any, in this connection, or in this connection. Accordingly, to the limited extent indicated, the court would allow the parties some time for the same. The matter will now appear after 2 weeks. That we pass.
After 20, any date, Lordship?
Yes, there'll be 2 weeks.
Okay, Lordship.
Or should we fix a specific date? 23rd.
23rd, okay, okay, Lordship.
This is matter on 23rd. In the meantime, till such date, till the next date fix, the impugn order dated 17
May
May
2023
under bracket Annexure 7 to the petition is hereby kept in abeyance. Let's hope we can work it out, because we have to understand these are all beneficial legislation.
Absolutely.
It is for the benefit of the employees.
So by freezing the
You
account,
as the employer has a duty cast upon you.
Absolutely.
Actually, what happened, Lordship, this is we have the account would not have been freezed if the sufficient amount had been there. So since there is the amount is less than sufficient, that is why it got freezed. Because had there been sufficient amount where we can recover the amount, that it would have been no Lordship. Because I know now, I know, that is why I am saying that had there been sufficient amount, because I am aware since being the council, I am aware.
Can they do that? If there had there been a sufficient amount, can they just withdraw it?
Lordship, the power to recover is there. Power is there, because they have, because the Lordship.
Even so, you see, notice has to be issued to them. They have to be, you see, they have to be made aware of the steps that they can take for to defend such action.
The common practice is that the people are never aware. What happens is the orders are issued to them, but the ultimate recovery is not communicated to the person concerned. It is communicated to the bank, and they take it out.
Fine.
Obliged, Lordship.
Obliged, Lordship.
Item number 3.
Lordship, this matter, we are aggrieved, my lord, by the non-supply of the food grains to the petitioner's fair price shop since the month of April. My lord. My lord, the short issue here. Kindly have, my lord, page 25.
Yes.
Page 25, my lord, is the first appointment order. This is dated, my lord, 27th February 2020. And at point 2, my lord, lordship will find appointment valid till the end of the year. So this has been given to my lord Srimati Nazma Bibi, who is the petitioner hearing, for being the dealer of the fair price shop, my lord, at Pushkarni Para Center. And her certain conditions have been attached therewith, my lord. So this was, my lord, the initial appointment in 2020. Thereafter, my lord, for the years of 2021 and 2022 as well, it was the petitioner who was extended, and she had been running the fair price shop. Now at page 26, lordship, page 26, annexure 2, my lord.
Yes.
This is for the year 2023, my lord. Lordship will have the date on the top.
Yes.
And under the provisions of so and so, Srimati Nazma Bibi is hereby renewed as fair price shop dealer of Pushkarni Para Center under Demdema CNRD block with immediate effect. She is to observe the following instructions as laid down in so and so order. The second point, my lord, her appointment shall be valid till 31st December 2027. So a 5-year appointment has been given to me. And I am still running the fair price shop. Lordship, at page 27.
Yes.
My lord, what happens is the fair price shop, my lord, is run by a particular dealer. And all the ration card holders come and take their respective ration from that particular shop. But the supply, my lord, comes from the government. Either the government directly supplies it or it is through a designated warehouse. So, my lord, in our case, it was from a wholesale designated warehouse. Lordship will find at page 27. This is for the month of March 2023, my lord. This is an excerpt of the register by which the supply has been made. This has been issued by Sub-Inspector of Supply, so and so, my lord. So this has been issued to the wholesale, the warehouse, my lord, the wholesale warehouse for the month of March 2023, and the quantities of different types of rice have been given. So these are all to be supplied to my fair price shop, lord. So for the month of March, they have come and they have already been supplied in pursuance to this sanction. Thereafter, my lord, kindly have page 28, next page. Lordship, this is a complaint filed by the Gaubura of the village, as well as some other villagers, and also the Vigilance Committee. Now, Vigilance Committee, my lord, is the designated group of people who are assigned the task to supervise the activities of the fair price shop. So, these three groups of people, my lord, the committee, the Gaubura, as well as the common villagers, wrote to the, my lord, respondent subdivision officer supply on 1st of May, my lord, an appeal from the genuine ration card holders come with Public Vigilance Committee of so and so shop under Demdema CNRD block. With due respect and reference to the subject cited above, we, the below undersigned, would like to inform you that we are having FP shop for our village, Pushkarni Para, and the dealer is Srimati so and so, which is running very smoothly without any complaints since long. She always maintains good cooperation among ration card holders and even maintains transparency. She never misbehaves amongst us, and we do collect our food grain commodities very easily without investing any single rupees. But sir, unfortunately, it is seen that some vested interested person of our village unnecessarily trying to create chaos and making false allegations against the existing FPS, which is fair price shop, my lord, for their own benefits and interest. That sir, we would like to draw your kind attention for the fact that all our neighbor ration card holders already received the food grains for the month of April 2023. But sir, we did not receive the same. Most of we people belong to BPL category, so we need our deserving commodities at the earliest. Therefore, this is a sincere honest request and appeal to you to keep our existing FP shop as it is without any change. So the position, what happened, my lord, is the month of March, there was no adversity. The food grain rice was supplied to my fair price shop and they were distributed accordingly, my lord, to all the ration card holders. There was no complaint. But it appears, my lord, that some people may have complained against my fair price shop to the concerned authority, and perhaps as a result of that complaint, the sanction for food grain since April 2023 has been stopped, my lord. But it is my categorical submission, my lord, that no show cause, no inquiry, no such intimation of any such complaint has been given to me whatsoever. And if at all there is any such inquiry, it is completely unbeknownst to me, my lord. So the only thing that I am faced with, my lord, is the entire village coming and asking me as the fair price shop dealer to give the ration, my lord. Now it has been pending for April, and also May has also, my lord, come to fore. For 2 months, my lord, rice is not being supplied to that particular fair price shop. And even if there is a complaint or no complaint, my lord, that has to take its own course as per the law. But to stop my to stop the supply of the very rice grains to the fair price shop, my lord. At this stage, I am aggrieved by that, my lord.
What is the order to stop supply?
No, they just simply have not given, my lord. Which is why the villagers and the vigilance committee also have written that
Yes.
May I please, Your Lordship, I'm accepting notice on behalf of all the state respondents.
You can do that. You can file your affidavit.
Yes, Your
But in the
Lordship.
meantime, why have you stopped the...
So, Your Lordship, without instruction, I can...
Without instruction, even then, without due notice, you cannot just, randomly stop supply.
But there is
Otherwise, you could
nothing.
have... Otherwise, if there is a complaint, though it's not on record as yet...
because nothing has been served on me.
Nothing has been served on the petitioner. What you could have done is, you should not,
Yes, Your Lordship,
what you should do is, you should consider the plight of the villagers.
Yes, yes. So in that
For the
even
fault of somebody, they should not, they should not suffer. You should have made alternative arrangement in the meantime, if that is possible or not. But you cannot stop.
So in that event, Your Lordship, I am accepting notice and I'll seek instruction and get back.
My humble prayer, my lord, would be that let them take instructions, my lord, if there is
Let this matter come
3 weeks time, maybe, because
on
it
one-
is Dadangiri.
No,
Your
you
Lordship.
get you first you get your instruction firstly as to how the supply has been stopped.
Yes, Your Lordship.
If it is based on a complaint, why the complaint, the petitioner was not issued with that complaint, and the reasons. You take step for counter, and by Monday you file it.
Monday it is not possible. Your
Get the
Lordship.
status report. If not on Monday, get the status
I
report.
would pray, my lord, that if lordship is pleased to make an observation that they may, if there is no otherwise embargo, they can, my lord, the pendency of this proceeding should not be a embargo to release the supply to
But
my shop.
without getting
But if there
instruction, Your
is,
Lordship.
if there is a specific complaint
Yes,
against
if,
you,
my lord,
if there's a specific complaint which is material, or rather linked to the non-supply, then that has to be dealt with. Now, if that is allowed to at this point of time, then it would amount to
Very
no
well,
complaint at all.
because my case is that, my lord, we don't know anything. One fine day, my lord, the supply has been stopped.
So that is why, let the status report be filed by Monday, and you can
Monday.
deal with the matter accordingly.
Your Lordship, 1 week, at least 1 week time may be given. Because Saturday, Sunday, 2 days, Your Lordship. It's not possible to file on Monday.
Okay. Tuesday then.
Wednesday.
Look at the you don't consider this as adversarial, in the sense that you have to think
Yes,
of
Your
the plight of the villagers
Yes, Your Lordship.
for no fault of theirs.
Because
Now
there
they
is
are
nothing on record to show that why it was stopped.
yes, that is
So
why.
that
That is
the
why.
thing.
But the fact is, it has been stopped.
Yes. And in fact, we also, at least the petitioner herself, does not know why it has been stopped.
Yes, Your Lordship.
Heard. To ask them, there are counsel for the petitioner, Miss S. Versadi has accepted, and Leonard J has accepted notice on behalf of the
Yes,
respondents,
155.
all the respondents, and as such, no formal notice is required. As prayed for, the Leonard J has. The Leonard J has submitted that the counter affidavit may be allowed to be filed
Okay.
in this regard. However, it is pertinent to mention at this stage that the grievance of the petitioner is that she is an authorized, what do you call yourself?
She is the fair price shop dealer, madam.
Fair price shop dealer, duly authorized by the government to disburse food, grains, etc. to the villagers of Pushkarnipara village in the Dadangere civil subdivision of West Garo Hills district. It is the complaint. It is the contention of it is the assertion of the petitioner that for the last 2 months, that is April and May, the supply of food grains to the said fair price shop has been stopped without any reason or any complaint being made known to her. In all of this, it is the villagers who has suffered the most and who have also petitioned the relevant authority in this regard. Be that as it may, to the limited extent as to why the said supply of food grain was stopped, as far as the consumer in the village is concerned, the respondent authority are directed to file a status report in this regard. Within the next date fix. This matter on 13 June. Maybe. Dan hearing?
Number 4.
Dan hearing dan. Dan hearing dengan saya ni. Kita segini ke orders.
This is a case where by total non-application of mine, the department has passed my final bill in minus. Here, even that time it was VAT which was applicable, and as per the terms of the contract agreement, the rates which were quoted were inclusive of taxes. So accordingly, we have deposited all the VAT from time to time, and the VAT was 12.5% for a certain period, then it was increased to 13.5%. Now we have the certificates issued from the Superintendent of Taxes.
Who are you?
I am the construction company, and where I have done some work under the CWE, Commander Works Engineer and Garrison Engineer. So from time to time, I'm still working with the department and some other projects. And so regularly, I'm a registered under the VAT. So, and we have been that has been regularly from time to time deposited. And the certificates were also issued by the department that in connection with that particular contract agreement, there was no dues, and I was not required to pay any taxes. And in fact, excess amount is lying deposited, lying with the department to be adjusted in future. In spite of those, and the copy of those certificates were also given to the Garrison Engineer Shillong. Now, in spite of that, and in 2013, I submitted my final bill in connection with this contract agreement. Department was not settling my bill for one or the other reason. Once they have said, when I have started writing to them, they kindly settle the bill. And then they have said, the bill is pending in the office for want of your signature on a particular document. So that was complied. Then thereafter, once they have communicated that there is one amount is due, which was, certain goods are supplied by the department, like bitumen is supplied by the department. So there was excess supplied, for which they have to recover the value of that from me. That was fine. So that is an amount of around 3,000 something was recovered from my final bill. Even after that also, my final bill was not settled. I raised my final bill, it was somewhere around almost about 34 lakhs or something odd was due. And it was not settled. But finally, now they have settled my final bill. They have said, pass the final bill on minus 52 lakhs something on minus side. On the ground that there alleged to be some dues on account of VAT and labor cess. Whereas the VAT statement certificate, the labor statement certificate issued by the department, signed by the department official, shows an amount of only 1,200 something was to be recovered. And even the VAT certificate also showed the amount is already paid. But without application of mind, they have passed the final bill on minus and then issued a notice to all the CWEs and the Grayson engineers to recover that amount from any other dues, my dues, if under any other contract. Now I have 3-4 other works going on with the department. Somewhere I have filed my final bill, in other I have to submit my final bill. Now, in this case, if they recover it from my bill again, then there will be again long drawn proceedings will be there, to recover that amount. And we might not, this is in the business, the money keeps rolling. They have to again invest. Now, if that amount is again recovered from my account, whereas my due is not paid, but on the contrary, if any amount is illegally deducted or recovered from my other dues, it will create a lot of inconvenience to in my business also, Your Lordship. Now, I will just like to take Your Lordship's attention to this particular certificates. First, Your Lordship will see, if Your Lordship will kindly turn to page 11, where I have shown the breakups. As per the formula under the Act, my total due comes to around 1,63,81,736 for the entire work that I have done. The work was for 16 crore something, plus with escalation, total value was around 18 crore. So on that, for work up to amount, up to a certain amount, it was at the rate of 12.50%. After that, the VAT rate was increased to 13.5. For the balance amount of work, it was charged at 13.5. So on the total amount, when you say my total tax due comes to 1,63,81,736. Where is Your Lordship will see, if Your Lordship will kindly turn to page number 19, my lord. This is from Superintendent of Taxes, Circle 2, Shillong.
Yes.
An application in Form 24A has been received from the authorized signatory of Messrs. Prasad Construction. Name is a registered dealer holding registration certificate number sensor under the Meghalaya Value Added Tax, and duly supported by documents as here under. Your Lordship will see the. And after having gone through the said document, I am satisfied that a contract number such and such pertaining to provision of this at Shillong is a divisible work contract. I therefore certify that on the value of the contract agreement payable to the dealer against work value of rupees 11 crore something, no tax is deductible at source for the following reason: but dealer has no liability to pay tax. Up to that stage, the certificate is that I have no liability to pay tax. Dealer's tax payable determined for the period 1st April 2010 to 31st March 2012, amounting to rupees 19,58,158, which adjusted from tax deducted at source, made by the GE Shillong, and ITC allowed an advance payment made by the dealer. Excess tax at dealer's credit after adjustment of amount payable during the period for the same period is rupees 34,70,488, which is an excess amount as on that date. Then next certificate is issued on 26 March 2013 for the another period up to 31st December 2012. It shows, Your Lordship, amount of 3,63,27,000 on that against that work. I have already paid. Page 20, my lord. This is also a certificate at page 20, Annexure 5.
Yes.
This is for the next period, 1st April 2012 up to 31st December 2012. This covers my entire work. Here also they have certified that no tax is deductible at source for the following reasons: dealer has no liability to pay tax, and dealer's tax payable for this period, which that is the work amounting to this, is 25,95,142, which has been paid, and an excess of excess tax at dealer's credit after adjustment of amount payable during the period is 25,17,185. This is to be adjusted against future liabilities or deductions. So the certificate is there. In spite of that, now, department has issued this letter, the impugned letter. Page 32, Annexure 12, outstanding recovery from contractor. The details of outstanding recoveries against a contractor pertaining to this division are given in Appendix A. It is therefore requested to recover the said amount from the payment due or becoming due to the contractor and intimate voucher number and date under which recovery is effected to this office for further action, please. This was issued by the garrison engineer, marked to all the garrison engineers for all over the places wherever the person is working, and the annex documents here, page 36, Your Honor, my lord, page 36 at the bottom. This is the My Farm, which is showing this amount 56,05,861. Page 36 at the bottom, Your Lord.
Yes. This is the amount of recovery.
Now they are saying this, my final bill has been passed on minus for this amount, and this they want to recover. And then pursuant to that, notification has also been issued to all the departments to recover that amount.
Where is that?
Page 29, Your Lordship.
29.
It is from the accounts officer, CDA Guwahati. Final bill from minus 56,005,861 has been pre-audited and passed from CDA Guwahati letter number cited above. In this connection, it is requested to comply with the observations to CDA Guwahati's above letter number and forward their reply to CDA Guwahati at the earliest under intimation to this office. So now CDA Guwahati, who finally passes the bills and all that, they have issued this order that final bill is passed on minus 56,05,861.
So if it is a minus bill,
yes,
then that means this amount has to be
recovered from you. Whereas and the ground what they have given, it is on account of labor and VAT required. Whereas I have already paid. There is no dues for labor and VAT.
Okay.
Well, this is not the first case. Earlier also such cases has happened where we approached this honorable court, where for another party, where they have paid all the VAT regularly and they also had the certificates from the superintendent of taxes, but in spite of that, the CDA from Guwahati, they again demanded that this amount for this period, without application of mine, at random mechanically notice of suit, and his bills were suspended and his bills were not cleared. Then when we approached this honorable court had asked the CDA to appear in person and explain. At that stage, they reconciled the matter and they withdrew that notification which was issued. This was in, with case number what? 2015, such a case has happened earlier also.
Can you give that reference?
I can give the case number. We have applied for a certified copy till 2015. The order was not available with me. Yes. So here, Your Lordship, now, if in view of this notice that they have issued that to recover from my outstanding dues, and it has been circulated to all the Gs, anybody may, for my pending bill, I am not in a position to file my pending bill because they will immediately deduct it. And whichever already filed from there also they may. The apprehension is that they will recover that and they have to comply with this directions. That is why I have come with a prayer also, if Your Lordship, in the meantime, we can reconcile the amount. Now, we ask for the copy of the final bill. Your Lordship, if Your Lordship will kindly turn to well, I'll just like to draw Your Lordship's attention first to page number 21, where we had written to them that in reference to the subject, to the garrison engineer, we had requested that final bill of subject CA was submitted in the month of November 23. 4 years time has been passed since submission of our final bill. Due to your negligence, a huge amount of our is blocked since last 4 years. We are also losing interest and business of that amount. You are requested to expedite your process of paying the final bill. Your negligence will force us to claim interest on pending amount for the entire period. Then again we have written to them 10/11/2017 that reference to your letter number nil G Shillong. It is further stated that your above referred letter is intimated that final bill is subject CA was forwarded to AOG Shillong White Office letter. Considerable time has passed, but no action has been taken by AOG Shillong to finalize the final bill. Your kind attention is drawn to the abnormal delay in finalizing of final bill of subject CA due to negligence of department. Hence, you are requested to give suitable direction to the concerned officer to finalize the final bill of subject CA at the earliest. They kept the final bill pending for so long, and then next, your lordship, page 23. Again, we have written in 30th May, or it has come from them on 30th May 2018. They have informed that GE Shillong office has informed us your final bill bearing dated 24th November 2013. Telephonically discussion made between this office and your good self. It has already been intimated by their letter that the final bill is still lying with this office in want of your kind signature over DO number 20. Hence, you are hereby again requested to attend this office and put your signature. At no point of time there was anything that our final bill was in the minus. Only thing they asked if signature was not there. And then page 24, your lordship, in May 2019. Here also they have intimated. It is intimated that your firm was requested to return 100 kg of over-issue bitumen via above referred letter. However, it is noticed that you have not returned the same till date. In order to finalize the subject final bill, recovery at double the issue rate is hereby made as per calculation details given below. So this is a given below amount to be recovered rupees 3,407. If my final bill is in the minus even at this stage, how could they recover from the final bill if it was in the minus? So that itself shows, your lordship, that till that stage my final bill was not in the minus. Then they have issued this letter on 16 November 22. It is intimated that after please refer to headquarter Guwahati letter, and it is intimated that after recovering amount of labor cess and VAT from final bill. This is in 2022. The final bill has become minus and final bill passed on minus side. Hence, you are requested to deposit MRO of rupees 56 lakh. This is what letter which has been issued. And this MRO has been supplied to us for signature. Now, when we requested them, your lordship, this is the order passed by the CDA office, accounts officer CDA, on 1st September 2022, based on which GE office has issued this letter. First September 2022, the CDA office from Guwahati, they have issued this letter at page 30, my lord. Final bill bearing voucher dated has been pre-audited and passed for minus 56 lakh 5,861. And based on this letter dated 16 November 22 at page 25 was issued by the GE Shillong.
Anyway, what is to be determined here?
My lord, only one more thing I would just like to... Then thereafter, your lordship, by page 31, we asked them to supply copy of the final bill or not. They initially did not give us, but finally they had given us a copy. And when we perused the final bill, your lordship, the big mistake that they have done in calculating, as per the contract agreement, all our rates were inclusive of taxes. This was a requirement of the contract agreement, your lordship. The lump sum amount quoted against Schedule A, Part 1 to Part 13 and unit rates quoted against item created for under Schedule A, Part 14 shall include all tax duties, that means VAT on materials, excise duty, custom duty, VAT on work contract, octroi duty. So our rates which we have quoted already was with the tax inclusive of the tax. Now they have calculated the tax on top of that rate quoted by us, and that is how they have come to a big amount. But besides that also, that is one non-application of mine on their part, which is against the contract terms and conditions. That is a miscalculation. And then when we peruse the final bill that they have settled, they have corrected, there we have found that, Your Lordship, it is their own, that page 42, the last page, if Your Lordship will see, Annex 16, Labour Chest Statement.
Page?
Last page, page 42, my lord. This is a document of the department.
Yes.
And this is as on 25th November 2013. That is the date of submission of final bill. My final bill was submitted on 24th November 2013. As on that date, the department has made as a labour cess statement where it is showing that my balance to be recovered towards labour cess is only 1,272. It is only that amount. Whereas now from the final bill that they have made all the corrections, cutting and so many corrections they have made. I have given a typed copy of that, Your Lordship. Page 38 is my final bill which was submitted, dated 25th November 2013. On this, they have wrongly at the back page, as page 39, if Your Lordship will see, for towards labour cess, they are correcting amount 7,72,512. Bitumen, same amount, correct amount. If Your Lordship will kindly turn to page 39. Page 39.
Yes.
And the top part in that table portion, if Your Lordship will see.
Yes.
Initially in that bill, because there is no due from us, so when in the final bill, when it was prepared, it is showing towards VAT also nil, towards labour wages only 1,272 was showing.
Page 39.
Page 39. If Your Lordship will see, the serial numbers are there. Deduction of VAT nil, because there was no VAT due. Deduction of labour welfare only 1,272, but it was nil, but they have written 1,272 initially. Again, it is corrected just below there only. If Your Lordship will see some corrections handwritten. Towards labour says 7,72,512 has been shown, and bitumen 3,408. That is okay, 3,408. That is same amount which they have recovered. But labour says from this own statement, their own documents is showing towards labour it is only 1,272, which was initially written 1,272. But again they are correcting and they are calculating it at 7,72,512. This is at random, without application of mine mechanically. They are just making, somehow they have brought the bill for reasons best known to them, Your Lordship. Their accounts office on CDA, they have passed my final bill on minus. So,
yes, Dr. Musika, tell me.
My lord, it appears to be some accounting issues, my lord. In fact, the officer was here. I called him. He said the petitioner has been called tomorrow, my lord, to the office of the respondents, and to reconcile the statements, my lord. So we can, if some time is granted, maybe the matter will be resolved, my lord.
So notice may be issued, and meantime then petitioner will go. But I am not aware that my petitioner has been called. That part
has been called tomorrow itself.
Must be. They have to only.
You should have just made the submission, and all this thing would have.
My lord, I wanted to, but
just wasting my time.
Matter was in flow, my lord. I didn't want to disturb the flow.
It could, if there is, you see, if apparently you have also admitted that there's some calculation mistakes, so that can be sorted out.
That is only issue, my lord. There is nothing more than that. Though the writ petition is not maintainable, I am not raising that issue. The arbitration clause is there. I'm not raising that issue because the matter looks like it's very likely to be resolved, my lord. So, my lord, 2 weeks time is granted, and as far as stay, my lord, this order, this letter, my lord.
See, you go tomorrow.
Yes.
And once the matter is resolved, in fact, what we do is we'll list this matter for 1 week.
1 week may not, because.
So 1 week means, in the meantime, what happens is, see, 1 week, if there is some positive, outcome tomorrow, then by that time you can make your submission before the court and matter ends there.
This order, recovery order may be stayed.
This order is of March, my lord. We are in June now. Nothing has happened. Nothing will happen.
No,
madam.
they may
Let us do one thing. Since it has been submitted at the bar,
Yeah. That may be recorded. That they will not recover till then.
no course of action may be taken in the meantime.
Because what has happened means, in case any of the CWE, without knowing, there's so many
because you have not
CWEs.
yet presented your final bill.
I have found in some cases that 4 other cases which is pending with the department under different GE and different CWE. So without knowing, they have to, if they just comply, then again I have to be unnecessarily harassed, approach and file the case and to recover that amount. So that is why, Your Lordship, since if chances of settlement is
Madam,
there.
kindly see only two documents also, my lord. Page 25, my lord. That is dated 16 November 2022, my lord.
Yes.
This is the main letter, my lord, where he has been asked to refund 56 lakh rupees.
Yes.
This is, Lordship, kindly see the date, 16 November 22. Then page 32, my lord, for which they are asking for stay, my lord. This is page 32, my lord. 32.
32.
32, my lord. This is dated 15th March 2023, my lord. NHR 12, my lord.
Yes.
It is dated 15th March 23.
Now we are in June.
Now we are in June. And matter will be resolved, my lord. No, nothing will happen.
If that
may be recorded and he has been, I don't know, this is a submission made at the bar,
yes,
so I'm not
once heard Miss P.D. Bhuja Barwa, Learned Senior Counsel, appearing for the petitioner. Also heard Mr. Dr. N. Bhusika, Learned DSGI, appearing for the respondent. Before launching to the merits of this matter, the learned DSGI has fairly submitted at the bar that the respondent authorities have requested the petitioner to approach them for a meeting on tomorrow is 9th June, for which
to reconcile
a positive outcome is expected. In the meantime, notice has been accepted on behalf of the respondent, and if so required, the counter affidavit will be filed with the next date fix. As prayed for, this matter, let's fix a date.
After 10 days, my lord, they'll give you at least 2-3 extra days, my lord. 19th.
Fix this matter on 19th. In the meantime, as far as the impugn order, what is the, is it this page 32 is the impugn order?
32 and my lord.
The interim order was not required, my lord.
32, my lord.
As it is, they are coming after 3 months, my lord.
My lord, I humbly pray
Nothing
because
has happened in 3 months, my lord. Most likely nothing will happen in next 10 days, my lord.
Even if interim order is passed, my learned friend will
In
not.
the meantime, till the next,
they will not be affected in any manner, my
next
lord.
date fix, no coercive action may be taken against the petitioner.
For towards recovery, my lord.
Towards recovery.
That's all. Suffice.
In all probability, you will get your shares. So, what is there?
It's been Your Lordship, if your heirs on married and this honorable court, justice would have been done if this honorable court directs to pay with interest. Since 2013, my amount is blocked.
There is no amount, my lord. They have to pay the amount.
According to, yes.
According to them.
Fine.
And at the most resolved also, they will not get any money, my lord.
Whatever the case may be.
Yes. Obvious.
Thank you.
Very costless. Item number 1.
I've taken due steps, Your Lordship, in this case. ED cards are yet to return, Your Lordship.
It's for 5 and 6. All for all.
Yes, Your Lordship. 5 and 6.
So we await service.
Lordship.
You are appearing for the?
The state, Lordship.
Have you filed your counter?
Lordship, in some because 2 to 6 are connected matters, Lordship. So in some we have received paravised comments, the others we are still awaiting, Lordship.
But Mr. Letter Counsel for the petitioner was submitted that the notice and that the report on the notice issued upon the respondent 5 and 6 has not yet come, and as such has prayed for some time for the said report to be placed before this court. As far as respondent 1 to 4 are concerned, Ms. Njishila, learned senior GA, has submitted that the counter affidavit could not be filed today and has prayed for some more time for the same. As prayed for, this is matter of 2 weeks.
Much obliged, Lordship.
Obliged.
That's not been already.
Item 19.
That's not